Hello aspirants, welcome to Ekam Academy. Today we are going to discuss the recent declaration of 25th June as Constitutional Assassination Day by the Government of India. So in this context, we are looking what is the brief background of choosing this particular date and what is the significance of national emergency and all other important constitutional provisions related to emergency in a quick and informative way. So let's discuss here. So first thing we have to see is why it is in news. Recently, Government of India declared 25th June as Constitutional Assassination Day or Samvidhan Hatya Divas. So what is the reason why they have chosen 25th June itself is because, we have so far imposed national emergency 3 times. So out of these 3 also, 2 times it was imposed on the grounds of external emergency. One is due to 1962 India-China war. At the same time, second one is due to 1971 India-Pakistan war, that is India-Bangladesh Liberation War. So, and in another situation, we have imposed internal emergency, that was actually imposed on the grounds of internal disturbance. This was not anymore a ground for declaring national emergency. Now this was replaced by armed rebellion. But this is the only time when we have imposed internal emergency, but this was imposed between the period 25th June 1975 to 25th March 1977. So almost for 21 months. So we can say there is imposition of emergency. That is why they have chosen this particular day as the Constitutional Assassination Day. So then what is the main thing that happened during the opposition? So on the grounds of internal disturbance, so there is imposition of emergency. So what happened at that point of time? During emergency, especially national emergency, fundamental rights get suspended. So with respect to this, you have to keep one thing in mind is generally Weimar Constitution, that is German Constitution, has this provision of suspending the fundamental rights during emergency. That is where we have borrowed it from. And another thing is only in case of external emergency, Article 19 also gets suspended. So what things cannot be suspended is 20 and 21 cannot be suspended any time during the emergency. But in case of internal emergency, you cannot suspend Article 19. So this is what you have to keep in mind. Then another thing is, what is the most common thing that happened at that point of time is most of the people are detained. In Indian Constitution, we have 2 types of detentions. One is punitive detention as well as preventive detention. But at that time, so many of the political persons who are raising their voice against imposition of emergency, all opposition candidates, all they were detained illegally. So that is another common phenomenon. Then another thing is arrest of the opposition leaders. Arrest of opposition leaders. At the same time, there is no basic rights, or you can say political things are also so much manipulated at that point of time. So these are certain things which were observed during the time of national emergency, which was imposed on the grounds of internal disturbance then. So then what is another thing you have to keep in mind is, national emergency will be imposed on the grounds of war, external aggression, or originally Constitution has provided internal disturbance, but this now was replaced with armed rebellion. So this is under Article 352. So this can be imposed by the President of India in case of war or external aggression, or even if he thinks before also. If there is a chance of any war or external aggression, then also he can impose. So, this has to be on the aid and advice of the Council of Ministers only. And you very well know at this point of time when internal emergency was imposed, none of the cabinet ministers were aware of this particular decision. So, the Prime Minister has directly communicated to the President on telephonic conversation. That is the reason they have strictly made. So with this only, imposition 44th Amendment in the year 1978 had made it a mandatory thing that all the cabinet ministers have to write in return form with respect to giving their approval for imposition of national emergency. It is this time only the word cabinet was inserted into the Indian Constitution. Till then, there is no such mention of the term cabinet. There is only mention of the term Council of Ministers. But with this amendment only, the cabinet term got inserted into the Constitution of India. Right? Then what is another thing you have to keep in mind? What happens? Fundamental rights can be suspended, based on the types of emergency. only during external emergency Article 19 can be suspended, but all other fundamental rights which President of India notifies get suspended. You need to know only their enforcement is getting suspended, not the rights. Then another thing you have to keep in mind is Parliament becomes empowered to enact a matter in the even stateless subjects also. This is what you have to keep in mind. And any alteration with respect to financial devolution can also happen during the imposition of national emergency. Then what is a specific type of majority means? Original constitution has provided it needs to be passed by both houses of the parliament with simple majority only. But this was made as special majority by 44th constitutional amendment in the year 1978. Original constitution said it has to be approved within 2 months, but this was replaced by 1 month again by same amendment. And then you also have to keep in mind, so within this time both houses of parliament has to approve, and for every 6 months it has to be approved again and again. So it can continue for any period. So there is no restriction on this period. But see here, in case if the parliament is not approving beyond 6 months, it will not again it will not continue to operate. This is another thing. Once if they generally don't approve after the 6 months period, it will cease to operate. Then who can revoke? Generally revocation power is with the President of India, but if parliament passes a resolution, if agrees, like for example, if at least 1/10 of the members agree and they wanted to pass a resolution asking for revocation, this time only with simple majority, then President of India has to revoke the national emergency. Then you also have to keep in mind 38th constitutional amendment in the year 1975 made imposition of national emergency immune to judicial review, but this was again removed by 44th amendment 1978. So these are the main things which you have to keep in mind. So why the government is now declaring this 25th June as Constitutional Assassination Day is mainly they wanted to show the contributions or highlights of the persons who have sacrificed during the emergency. At the same time, they wanted to create awareness about the abuse of power so that these instances doesn't happen in the future. That is the reason they have chosen this date as 25th June as the Constitutional Assassination Day. If you have remembered which particular day is celebrated as Good Governance Day, answer in the comment section. At the same time, which particular day was chosen as a constitutional day, that also answer in the comment section. Then let us see the practice question given for the today. During a national emergency, fundamental rights guaranteed under articles which of the Indian Constitution can be suspended. So you have Article 14 to 18, Article 19 to 22, Article 20 to 21, 25 to 28. Which of these fundamental rights are guaranteed? Okay, so which can be suspended during this particular time? Answer in the comment section. Then, as we have reached the end of the video, today we have discussed about why Government of India has chosen 25th June as the Constitutional Assassination Day, and what is a brief background of this particular internal emergency, and also the constitutional provisions related to national emergency in a quick and informative way. If you found this video informative, please let us know. Thank you for watching. All the very best.